The morning they came for the estate, I was in the kitchen holding a mug that had already gone cold. It was 7:12 a.m. The heating had clicked off 30 minutes earlier, but I hadn't moved. I heard their car doors before the knock. 3 doors, firm, synchronized, like they had rehearsed it. They didn't say good morning. They didn't sit down. The eldest placed a folder on the dining table and slid it toward me with 2 fingers. We want the estate, the company, everything Dad built. He said it calmly, practiced. Their attorney stood behind them, silent, leather briefcase still closed. I remember noticing the condensation ring my mug left on the table. It overlapped the edge of the folder, slightly. No one moved it. I asked one question. Is this what all of you want? All 3 nodded. No hesitation. No grief. Just alignment. My lawyer called me 40 minutes later. I put him on speaker while they waited in the next room. Do not agree to anything, he said immediately. Papers shuffled on his end. You have standing. You can freeze distributions today. I looked through the glass partition at my husband's children, whispering, confident, already discussing asset sales like the outcome was settled. I picked up the pen anyway. I won't be fighting them. I told him. Silence. At the final proceeding 3 weeks later, I signed the full transfer agreement without revisions. They smiled when the judge stamped it. Their attorney did too, until he turned to the last attached filing and stopped breathing for a second. The first formal meeting happened 2 days after the funeral. 10 a.m. Conference room B. Harrison and Klein corporate offices. I arrived early. My lawyer, Daniel Reeves, was already seated, reviewing a printed inventory report. He had placed 3 yellow tabs along the right edge. He didn't look up when I walked in, only slid a second copy toward my chair. Preliminary estate scope, he said. Do not react in the room. The paper was heavier than standard print stock. Someone had upgraded the stationery for formality, company valuation summary, real estate holdings, operating accounts, minority investments. Halfway down page 2, I saw their handwriting, margin notes beside 3 asset categories. Liquidate, restructure, sell. They hadn't waited for probate. At 10:07 a.m., my husband's children entered with their attorney, Mr. Alan Crow. He was younger than I expected. Precise haircut, narrow tie. He shook Daniel's hand first, then mine, measuring grip pressure like it mattered. Folders opened in sequence. No condolences. Crow began speaking before anyone sat fully down. My clients are requesting immediate recognition of inheritance priority under corporate lineage provisions. Daniel didn't respond. He simply uncapped his pen. The eldest son pushed a second document toward me. Dad always intended the company to stay with blood, he said. Not angry, not emotional, administrative. I scanned the header. Executive continuity petition. Filed that morning, 8:42 a.m. I looked at Daniel. He leaned slightly toward me without turning his head. Do not answer yet. Crow continued. They're prepared to assume operational control immediately to preserve valuation stability. Preserve. An interesting word to use when you're trying to remove someone. I asked my first question. When was this drafted? Initial structure. Crow said, about 6 months ago. 6 months. My husband had been alive then, recovering from his second surgery, still attending board calls from home. I made a note in the margin of my copy. 6 months capacity. Daniel saw it, tapped his pen once. The meeting moved quickly after that. Transfer requests, board seat reassignments, voting consolidation, each item already formatted for approval. They weren't negotiating. They were executing. At 10:31 a.m., Daniel finally spoke. We'll need to review documentation validity, he said, particularly execution conditions. Crow smiled slightly. Of course, but we've already filed provisional recognition. He slid a stamped acknowledgement across the table. Filed. Accepted for review. Time-stamped 9:03 a.m. They had filed less than 20 minutes before the meeting started. I noticed the daughter watching me, not Daniel, tracking my face for reaction. I kept my posture neutral, and turned one page at a time. Page 5 included a corporate medical clause reference, something about executive incapacity thresholds. I circled the statute number without comment. Daniel saw that too. He wrote one word on his legal pad and angled it toward me. Obtain records. The meeting adjourned at 11:12 a.m. No one shook hands on the way out. In the hallway, the office printer was running continuously, the low mechanical hum filling the silence between us as Daniel walked beside me. You understand what they're doing? He said. Yes. They're moving before a state court defines your standing. Yes. We reached the elevator bank. Stainless steel doors. Reflection slightly warped. You can block this, he said quietly. Emergency injunction. 48 hours if we file today. I watched the elevator numbers descend. 8, 7, 6. They'd escalate, I said. They already are. The elevator arrived. We stepped inside alone. When the doors closed, he lowered his voice further. There's another issue. I turned slightly. He opened his folder and showed me a single clipped document. Corporate board minutes, dated 4 months earlier. Attendance list included my husband and all 3 children. I wasn't listed. They held a continuity session without notifying you, Daniel said. I read the resolution summary. Succession pathway, provisional, vote passed unanimously. My husband's signature was at the bottom, but the signature line was marked with an asterisk. I leaned closer. Why is there a notation? Daniel flipped to the attached appendix. Medical accommodation clause, signed under assisted execution conditions. The elevator reached the lobby. Doors opened. We didn't move immediately, meaning, I asked, meaning someone certified he required assistance signing. I thought about the timeline. 4 months earlier, he had still been driving, still chairing calls, still arguing with suppliers personally. Who certified it? I asked. Daniel pointed to the bottom. A private physician I didn't recognize. No hospital affiliation listed. We stepped out of the elevator and moved toward the parking garage corridor. The fluorescent lights buzzed overhead, intermittent flickers between fixtures. First step, I asked. Medical capacity verification. Daniel said, we request full treatment records covering the execution window. And corporate filings? Already pulling them. We reached my car. I unlocked it, but didn't open the door yet. Daniel, I said. He stopped. If I don't contest operational transfer, how fast do they move? He studied my face carefully before answering. Immediate interim control. Full asset maneuverability within 90 days. I nodded once. He hesitated. You're not seriously considering letting this proceed. I finally opened the car door. Obtain the medical records. I said. He placed his folder under his arm. And after that, I sat down, set my purse on the passenger seat, and looked at the estate inventory again, the words liquidate and sell still visible through the thin page. After that, I said, we document everything. I closed the door before he could ask anything else. The medical records request went out the next morning at 8:16 a.m. Daniel copied me on the submission. Certified release authorization. Estate executor standing. Expedited review request. He flagged the execution window specifically. The 14 days surrounding the board continuity session. By 11:40 a.m., we received the first resistance. Not a denial. A delay notice. Archived file. Retrieval required. Daniel forwarded it with one line. They're buying time. I printed the notice anyway. The office printer stuttered halfway through page 2, forcing me to clear a paper jam. I remember the heat coming off the machine. Dry, mechanical, impersonal. At 1:05 p.m., another email arrived. This one from the company's interim operations office, now formally headed by the eldest son. Subject line, operational transition schedule. No greeting. Attached was a phased restructuring outline. Asset review. Vendor renegotiations. Subsidiary divestment. Divestment was highlighted in yellow. I checked the date stamp. Drafted 3 weeks before my husband died. I called Daniel immediately. They prepared liquidation models in advance. I said. I assumed as much, he replied. Papers shuffled on his end. Forward me the attachment metadata. I did. He called back 20 minutes later. Authorfield lists their attorney's firm, he said, not internal finance. So, the legal team had structured sale pathways before inheritance was legally recognized. At 3:12 p.m., I drove to corporate headquarters unannounced. Security at reception hesitated when I asked for building access credentials. Those are under review, the desk attendant said. By whom? Interim leadership. I didn't argue. I signed the visitor log instead. Temporary badge. Level 2 access only. The elevator ride to the executive floor felt slower than usual. The overhead lighting reflected faintly off the brushed metal walls, duller than I remembered. When the doors opened, the hallway was quieter than normal. Fewer assistants. Office doors closed. My husband's office was locked. I stood there for a moment before knocking out of habit. No answer. Down the corridor, I saw the daughter exiting the conference suite, carrying 3 binders. She stopped when she saw me, but didn't greet me. You changed the access permissions, I said. Temporary, she replied. Compliance review. She didn't offer more. I nodded toward the binders. Divestment planning? Her grip tightened slightly. Stability planning, she said. Same word their attorney used. Preserve. Stability. Administrative language for removal. I returned to the visitor workspace and requested archived board minutes from internal records. The clerk hesitated. I'll need interim authorization. I waited while she made the call. Printer noise filled the gap, the rhythmic churning of a high-volume job running somewhere behind the wall. After 6 minutes, she returned. You're cleared for view-only access, she said. She led me to a terminal station and logged me in herself. I searched the continuity session first, then filtered backward 90 days. 3 additional meetings appeared that I hadn't attended, each marked as special governance session. I opened the earliest one. Agenda summary, executive resilience planning, medical contingency structuring, successor financial authority modeling. Each document referenced the same physician certification used in the assisted signature filing. I printed all 3. The paper stack felt heavier than expected when I lifted it, thicker legal stock again. I called Daniel from the parking lot at 5:02 p.m. They held 4 succession sessions. I said, attendance. All 3 children. Corporate counsel. The physician. Pause. Your husband. Listed present for 2. Proxy signed for 2. Proxy. Certified under medical accommodation. Silence on his end, not confusion, calculation. Forward everything, he said, finally. I sat in the car for a few minutes before driving home. When I arrived, there was a courier envelope wedged in the doorframe. No return name. Inside was a formal notification. Executive compensation, suspension. Effective immediately. My monthly disbursement had been frozen pending estate redistribution. Time-stamped 2:48 p.m. While I was still in the building. I placed the letter on the kitchen counter and made coffee, though I didn't want any. The machine beeped when it finished brewing. I poured a cup and left it untouched beside the envelope. At 7:36 p.m., Daniel called again. I reviewed the physician certification. He said, license is active, but privately contracted. No hospital oversight. Can we challenge capacity? Yes, but that's defensive. I don't want defensive. He waited. What do you want? He asked. I looked at the compensation suspension letter again. The phrasing, the speed, the administrative detachment, timeline mapping, I said, every filing, every meeting, every certification. Your building pattern evidence. Yes. Pause. Then we also subpoena financial communications tied to succession planning. Do it, I said. Before hanging up, he added one more thing. There's something else you should know. Go on. The divestment model they drafted? Yes. It prioritizes liquidation of the manufacturing arm first. I leaned against the counter. That division funds the pension trust. I'm aware, he said, meaning they weren't just inheriting. They were stripping. I ended the call and finally took a sip of the coffee. It had already gone lukewarm. On the kitchen table, beside the estate transfer folder they'd given me, I placed the physician certification copies, the governance session minutes, and the compensation suspension notice. For documents, same signatures, same certification source, same legal counsel. I aligned the pages carefully, edge to edge, and clipped them together. Then I wrote one word on the top page. Pattern. The subpoena filings went out 12 days later. Daniel timed them deliberately, not during probate hearings, but 2 days before the interim asset review session the children had scheduled with external auditors. Pressure works better when they're presenting competence, he said. At 9:14 a.m. that morning, corporate legal received notice requesting internal succession communications, medical certification correspondence, divestment planning drafts, board proxy execution records. By 10:02 a.m., Daniel forwarded me the first response. Not documents, an objection filing, grounds, estate hostility, and operational obstruction. I printed it anyway. The paper stock was thinner this time, rushed filing, standard copy weight. At 11:30 a.m., my phone rang. The eldest son. First direct call. Since the funeral. I answered on the second ring. You're interfering with transition, he said without greeting. I requested records tied to my husband's medical execution status. I replied, you're creating instability. Transparency isn't instability. Silence. Then a shift in tone. Less corporate, more personal. You already said you wouldn't fight us. I'm not. Then why the subpoenas? Documentation. Pause. For what? I didn't answer immediately. I let the silence sit long enough that he spoke again. You signed preliminary transfer acknowledgement last week. Yes. That means operational authority is ours pending court ratification. I'm aware. Another pause, longer this time. When he spoke again, his voice had tightened slightly, then stopped digging. I ended the call without responding. At 12:46 p.m., Daniel sent a second email. Subject, production leak. Attached was a partial compliance release. Not full subpoena response, but enough to meet procedural deadlines. They had released 3 email threads tied to succession planning. He highlighted one line in yellow. I opened the file. Thread dated 5 months earlier. Participants. All 3 children. Attorney Crow. Corporate physician. Subject line. Execution feasibility. I read the exchange slowly. The daughter. If capacity fluctuates, can assisted certification still stand legally? Crow. Yes, if physician affirms executive awareness at moment of signing. Physician. Condition manageable with guided execution. Another email 2 days later. The youngest son. Would proxy hold if sedation administered same week? Crow. Timing must avoid documented impairment. I stopped reading for a moment. The kitchen clock ticked loudly against the wall. 1-second intervals, mechanical, steady. I scrolled further. Final email in the chain. 3 weeks before the board continuity session. Crow again. Prepare draft resolutions. Will align signature certification with physician schedule. Not grief planning. Scheduling. I called Daniel at 2:03 p.m. You've read it, he said before I spoke. Yes. That's preliminary self-incrimination, he said. Intent coordination. Enough to challenge succession? Not yet, but enough to expand subpoena scope. We added 2 new requests that afternoon. Sedation logs, medication administration records. At 4:18 p.m., I drove back to headquarters, not to request records, to observe. The executive floor felt different now, quieter, but not solemn, more transactional. Assistants spoke in low voices. Doors closed quickly when approached. I passed the conference suite and heard voices inside. Crow's voice was identifiable, precise, measured. I didn't enter. I moved past and sat in the adjacent visitor lounge instead. The air conditioning vent above the seating area rattled intermittently, pushing cool air in uneven bursts. Through the glass panel, I could see part of the meeting table reflection. Documents spread across the surface. One binder open, near Crow's position. When the meeting adjourned at 5:02 p.m., they exited in sequence. The daughter saw me first. She stopped briefly but didn't approach. Crow exited last. He noticed me immediately, recognition mixed with calculation. "Mrs. Ellison," he said, "I wasn't aware you were on site. Visitor access." I replied. He nodded politely. "We'll be responding to the subpoenas through proper channels." "I expect you will." He adjusted the files under his arm. "Succession transitions are complex," he added. "Emotions can complicate clarity." I watched him carefully. "This isn't emotional," I said. He held my gaze for half a second, longer than comfortable, assessing whether that was true. Then he left. At 7:11 p.m., Daniel called again. "They're releasing medication summaries tomorrow," he said. "Voluntary. Court compliance window." "Good." He hesitated before continuing. "There's something else in the production leak." "What?" "Audio notation." I waited. The physician recorded executive confirmation sessions. "Recorded?" "Yes, for liability coverage. Do we get the files?" "If subpoena expansion holds." I looked at the email thread again, the line about aligning certification with physician schedule. They coordinated execution timing around sedation windows. I said, "That's what it implies." Daniel said, "Then the recordings matter." "They do." I ended the call and returned to the printed email chain on my table. For highlighted lines. For separate participants. All referencing medical condition timing relative to signature execution. I clipped those emails to the earlier governance minutes and physician certification. The stack was thicker now, heavier when lifted. Before filing them, I added a divider page and wrote 3 words across the top in black ink. Intent, documented, timed. The medication summaries arrived at 9:08 a.m. the next morning. 37 pages. PDF format. Hospital letterhead. Daniel forwarded them without comment. I printed them and spread the pages across the dining table. The paper edges overlapped slightly. The stack reached nearly an inch high. The key date was circled in red ink by Daniel. 4 months ago, board continuity session day. Medication log showed 2 administered entries that morning. 8:05 a.m. Sedative, low dose. 9:12 a.m. Pain management injection. Board meeting timestamp. 10:30 a.m. Assisted execution certification signed at 10:48 a.m. I called Daniel at 9:42 a.m. They certified awareness 36 minutes after sedation. I said, "Yes." "Is that standard?" "No." "Is it defensible?" "Not without contemporaneous cognitive evaluation." I flipped to the physician's note. Single paragraph. Executive responsive. Aware of document nature. No neurological assessment. No orientation checklist. No time-based confirmation. Just one sentence. At 10:15 a.m., Daniel filed an emergency evidentiary motion. Grounds: capacity impairment at execution. The court scheduled a preliminary review hearing for the following Tuesday, 5 days. At 12:03 p.m., my phone rang again. This time it was Crow. "We've seen your motion," he said evenly. "Yes. You're alleging medical misconduct. I'm requesting capacity clarification." The physician affirmed awareness. The physician also administered sedation within 90 minutes of signature. Pause. "Sedation does not equal incapacity," he said. "No, but timing raises review requirements." He shifted tone slightly. "If this escalates, it becomes public record." "I understand. And that impacts the company's stability." The company's stability was impacted when liquidation modeling began before death. Silence. Then, more clipped. "We'll respond in court." The call ended. At 2:17 p.m., Daniel received an expanded production packet. This one included the audio files referenced earlier, 3 recordings, each labeled by date and time. We listened together over secure conference call. First file, 2 weeks before the board session. My husband's voice sounded slower than I remembered. Clear but measured. "Physician, do you understand you're authorizing provisional succession planning?" My husband: "Yes." Physician: Do you understand the nature of the documents? My husband, I trust my children. Daniel paused the recording. That's not the question, he said quietly. We resumed. Second file. 3 days before the session. Physician. Will proceed with assisted execution next week. My husband, as long as it keeps things organized. No document explanation. No asset specifics. Third file. Day of execution. Timestamp. 10:44 a.m. Physician. You're signing the board resolution acknowledging transition protocol. My husband. Okay. Voice slower than previous recordings. Physician. You understand this limits your spouse's operational control? For second pause. My husband, if that's what's best. Daniel stopped the audio. We sat in silence. The clock in my office ticked steadily. Mechanical, not digital. That's the self-incrimination loop. Daniel said finally. Explain. Email coordination about timing. Sedation before execution. Recorded leading question about limiting your control. And he never defined the document. No, at 3:38 p.m., Daniel filed a supplemental motion requesting judicial review of assisted execution validity and physician conduct. Hearing moved up 48 hours. At 4:10 p.m., corporate legal sent a statement to the board. Operational continuity remains intact pending procedural clarification. They avoided the word challenge. They avoided capacity, but they didn't deny the motion. Tuesday morning, 9 a.m., courtroom 4B. The children sat 2 rows behind their attorney. No eye contact. The judge reviewed the filings for 12 minutes without speaking. Paper pages turned slowly, deliberate. At 9:17 a.m., he addressed Crow. Counsel, your physician's certified awareness 36 minutes post-sedation. Yes, Your Honor. Was independent cognitive assessment performed? Crow hesitated. The physician deemed it unnecessary. The judge looked at Daniel. Motion seeks temporary suspension of succession recognition pending evidentiary review. Yes, Your Honor. At 9:22 a.m., the judge ruled. Temporary stay on operational transfer. Medical conduct review initiated. Corporate authority frozen until clarification. The eldest son exhaled audibly. Crow leaned toward him immediately, whispering. I remained still. At 10:03 a.m., outside the courtroom, the daughter approached me for the first time since the funeral. You're tearing this apart, she said quietly. I'm reviewing documentation. I replied. You said you wouldn't fight. I haven't. She looked toward Crow, who was speaking urgently into his phone near the exit doors. This won't end well, she said. I adjusted the folder under my arm. It already didn't. That afternoon, corporate compliance issued an internal notice. External audit initiated. Medical certification, review pending. Succession resolution suspended. Employees received it at 3:11 p.m. By 3:26 p.m., investor inquiry emails began. By 4:02 p.m., the stock price dipped 3.8%. At 4:40 p.m., Crow called Daniel directly. Settlement discussion requested. Daniel relayed the message to me. What do you want to do? He asked. I looked at the stack of documents on my desk, emails, logs, recordings, board minutes, aligned in chronological order. Proceed, I said. The audit notices went out 3 days later. Internal first, then external. At 8:05 a.m., employees received a compliance bulletin titled Governance Procedure Review. It avoided names, but referenced irregular certification dependencies and succession authorization discrepancies. By 9:12 a.m., vendor partners received a secondary advisory, operational approvals temporarily routed through a neutral oversight committee. Control had shifted quietly but completely. At 10:30 a.m., Daniel forwarded the first regulatory inquiry. State Medical Board. They had opened a conduct review into the physician's certification practices tied to corporate governance filings. Attached was a request for sedation protocol justification and cognitive assessment standards. By noon, corporate risk management froze all divestment activity pending audit clearance. The liquidation models the children had commissioned were suspended automatically under fiduciary review rules. No announcement, just halted transactions. At 1:47 p.m., the company's pension trustees issued a protective notice to beneficiaries. Manufacturing division protected pending governance stability. The division they planned to sell was now legally shielded. I printed the notice and placed it beside the earlier divestment draft they'd circulated. 2 documents, same asset, opposite outcomes. By midweek, professional distancing began. Crow's firm submitted a formal statement limiting their advisory scope to inheritance interpretation, distancing themselves from medical certification coordination. Daniel read the filing aloud over speakerphone. Their firewalling liability, he said, at 3:05 p.m., a second notice followed, this time from the corporate board's independent directors. They had scheduled an emergency governance session to reassess succession resolutions passed during my husband's medical leave. Attendance mandatory, all prior provisional votes subject to revalidation. The continuity session they relied on was now under institutional scrutiny. Friday morning, 9 a.m., the session convened. I attended remotely through council access. The board chair spoke first. Given evidentiary submissions and medical review triggers, provisional succession recognition is suspended indefinitely pending outcome. No debate followed. Resolution passed unanimously. Operational authority defaulted back to estate holding, not me personally, but neutral trust control. The children lost interim command in a single procedural motion. At 11:18 a.m., Investor Relations issued a stabilization memo confirming leadership continuity under trust governance. Stock price recovered by afternoon trading. At 2:32 p.m., the medical board escalated their review, requesting sworn testimony from the physician and all coordinating legal representatives. Crow's name appeared on the witness list. By 4:10 p.m., his firm reassigned him off corporate inheritance matters pending review completion. Professional distancing had become formal separation. Monday morning, another email arrived, this one from the children's private counsel. Subject line, reconsideration discussion. They requested mediation regarding estate distribution positioning. Daniel read it, then asked one question. Do you want to engage? I looked at the original estate transfer agreement still sitting and signed on my desk, the one they expected me to contest. I already agreed to their inheritance. I said. He paused. Yes, but the context has changed. Not for me, I replied. I ended the call and returned to the documents spread across my table. Audit notices, board resolutions, pension protections, regulatory reviews. Institutional systems had responded exactly as they were designed to. Slowly, procedurally, without emotion. Nothing dramatic, just consequences moving through formal channels. I stacked the documents neatly, aligned the edges, and clipped them together. On the top page, I wrote one final label, System Response. The final probate proceeding was scheduled for 9:30 a.m. on a Thursday, 7 weeks after the first estate meeting. I arrived 15 minutes early. Same courtroom as the succession review, courtroom 4B. The hallway outside was quieter this time. No clustered attorneys. No media observers, just routine filings moving through the docket. I sat on the wooden bench across from Daniel. He reviewed the finalized transfer agreement one last time, though nothing had changed since the previous draft. You're still certain? He asked quietly. Yes. He closed the folder. The children arrived at 9:22 a.m. with new counsel. Crow was not present. They sat on the opposite side of the aisle, leaving one empty seat between each other. A small distance that hadn't been there before. No one spoke. At 9:31 a.m., the clerk called the estate matter forward. We moved to the front tables. The judge reviewed the settlement summary, already familiar with the preceding governance filings and audit triggers. Distribution uncontested, he asked. Daniel answered first. Correct, Your Honor. The children's counsel confirmed the same. The judge looked at me directly. You're transferring full estate ownership, including corporate holdings, without revision? Yes, I said. He paused briefly, not questioning the legality, just the finality. Very well. The clerk handed the agreement across the desk. Standard legal weight paper. thicker than copy stock, slightly textured under my fingers. I signed where the tabs indicated. 3 signatures. 1 initial. No statements made. The judge stamped the filing at 9:42 a.m. Inheritance transfer ratified. The children smiled, restrained but visible. Relief more than triumph. Their counsel shook their hands quietly as we gathered our documents. Their attorney flipped through the attached filings included in the probate packet: estate inventory, trust disclosures, corporate governance status. He turned to the final attachment, then stopped. His posture changed first, shoulders tightening slightly. He reread the page, slower this time. The eldest son noticed. "What is it?" he asked. Their attorney didn't answer immediately. He looked again, then leaned closer to the document as if proximity would change the words. Finally, he spoke, low enough that only our tables could hear. "This estate transfer doesn't include operational authority." The son frowned. "What do you mean?" He turned the page toward them and pointed to the attached governance ruling. Corporate control remains under independent trust oversight pending medical certification litigation and board revalidation. Silence settled across their side of the table. "You inherited ownership," he continued carefully, "but not command." No one responded. The judge called the next case, signaling proceedings were finished. I gathered my folder and stood. Daniel did the same. We walked out of the courtroom without looking back. Outside, the late morning sun reflected faintly off the courthouse windows. The air felt colder than it had earlier. On the courthouse steps, Daniel stopped beside me. "You're aware you retained structural protection even after transfer," he said. "Yes." "And you're comfortable with that outcome?" I adjusted the strap of my bag on my shoulder. "They wanted everything he built," I said. "They have it." He studied my face briefly, then nodded once. We parted at the curb. I drove home, parked in the same spot I had the morning they first came to the house. Inside, the kitchen looked unchanged. I made coffee out of habit. The machine beeped when it finished. I poured a cup and finally drank it while it was still hot. No calls came that afternoon. No emails marked urgent. Just routine estate closure notices and automated confirmations. I rinsed the mug, placed it in the drying rack, and turned off the kitchen light before leaving the room. Life continued. That was enough.